So my background is I spent several years as a professional land surveyor before I became an attorney. I've been an attorney for about 10 years now. And one of the things that I really strongly feel for is issues that arise between neighbors that have something to do with the lack of understanding about land location. So that probably makes sense with my background. But one of the problems that I see in California and with many of the neighbor disputes that I'm involved in is that there's some uncertainty about property lines, and that adds to either the distrust that is already sort of is creeping up between the neighbors and making it difficult to resolve a problem, or is the direct problem. So I'm going to touch on that quite a bit during my topic. Just as a matter of housekeeping, if there's questions, I don't have the ability to see all 40 or so people who are attending. So if you do have a question, just put something in the chat. I've got that up on my screen. I'll take a look at that with each slide. And if I see somebody has a question, I'll try to answer it there if it seems appropriate. I'm not sure if you can unmute yourself, but if so, I'll call on you and you can unmute yourself and ask your question. So let's go ahead and get started. So what's the point of trying to preserve relationships? That's kind of the emphasis on my talk today, is trying to preserve relationships in a dispute. In a business sense, it often, it's self-explanatory because you have a pecuniary interest in the business relationship. But among neighbors, especially in our modern day subdivisions, our homes are almost completely self-sufficient. We don't really need our neighbors for anything. And that allows us to have kind of an existence very close to people who we may not know at all. And yet, in a lot of ways, we are dependent on them just for things that we might not think about. For example, if your house catches on fire, your neighbor is most likely the person who would see that if you don't, and would call the fire department. Neighbors often look out for each other in other ways, even when it's not done by agreement or formal legal contract. So when there is a dispute between neighbors, the emotional involvement is very high. In fact, it runs so high that in this case I have on the screen, it resulted in murder. And this is not the only case where this has happened. In doing the research for this, I found quite a few other examples where serious bodily harm or outright murder were involved in disputes between neighbors. And I think if we look at the news, we see many instances of people's emotions getting the better of them, and them committing acts that in probably different circumstances they wouldn't have committed. In my own practice, I've seen cases where certainly I've never been involved in a case that involved murder, but I have been involved in cases where I had to file an emergency injunction request in Superior Court to stop the neighbor from doing something that was harmful, to ask for an injunction. I've seen other cases where the neighbors acted irrationally to the point where there were, other civil lawsuits that involved, harassment or threats of violence. So it's certainly a part of this of this type of case, and I think we need to be aware of that. And as attorneys, we need to try to help our neighbors understand that while the legal avenue may be objectionable, it's better than the alternative. And when you have an uncooperative neighbor, that may be difficult to to convince your own client of, or to bring the other party to the table. But it's certainly something that we have to try to accomplish. So our agenda for today is going to go over these points here. We're going to look at a tension, an ethical tension that exists to start with between attorneys representing their clients as they ethically have to, while still seeking to preserve relationships between the neighbors. We're going to look at how boundary uncertainty can create part of the problem for these disputes. We're going to look at some other hurdles to resolution. One of those is managing client expectations. We're going to look at why California lots are in particular susceptible to property line disputes, and then some takeaway best practices that I've found in my own practice that I hope is helpful for attorneys and for neighbors that might be watching this CLE credit. So ethical tension. I'm sure if you're an attorney, you were made aware of this term, zealous advocacy. It's a classic term in law school, and it makes sense in the case of a high stakes defense of an alleged criminal. You want to use the utmost zealous advocacy in that case. However, for neighbor disputes, it's not quite as clear that that's the best type of representation. So where does this zealous representation come from? Well, that word zealous does not show up at all in the California rules of professional conduct, and that's what governs California attorneys. So let's take that off the table early. Zealous representation is not an ethical requirement for California attorneys. So where did that word come from? Well, it came from a footnote to the ABA model rules for professional conduct. And in that footnote, it did use the word zeal or zealous. And of course, it's been a tradition within the law for a long time. This references to an article by these authors, Daniel Harrington and Stephanie Benecci, and they propose removing that footnote entirely and replacing that word zeal with something more appropriate. But that is a history that attorneys have, is this concept of zealous representation. And I argue that, and I agree with these authors, we should remove that, particularly in the case of neighbor disputes where preserving the relationships between the neighbors is a high priority. So with that priority, we have slightly different goals. We want to place the emphasis on maintaining or restoring a relationship. In these types of disputes, often the property owners become so embittered that they sell their properties and they move away because they cannot stand to be next to the other neighbor. There are often physical health consequences as a result of these disputes. That's very, very sad to see, but I've witnessed it many times. So part of this is going to be listening not to just your own client, but if possible to the neighbor. And if that neighbor is not represented by counsel, you can listen to them directly. You can have a direct conversation. When they're represented by counsel, then it's important for the counselors to understand that they need to communicate to the counsel across the table. What is their client feeling? What are the issues? What are the emotional baggage that is being borne by their client, and share those things across the table. And that's not something that attorneys necessarily will do naturally. Try to understand what is the unstated issues, things that people aren't talking about, either because they're ashamed of them, or maybe they're not even aware of them. You may have to read between the lines to understand these things, but understanding the unstated is a big part of this practice. And then trying to bridge the differences. We'll talk more about that in some of the next slides. So how do we balance being an advocate for our client while also trying to play this more neutral role of finding a resolution to two parties who we hope will continue to have a productive relationship for the rest of their lives with each other? So I believe you should start off with being honest and even-handed. Say what you mean what you say. Don't use too much legal jargon. Don't try to overwhelm a party with sort of rules. Try to stay simple. You can begin with your client, of course, but remember that that also holds true with opposing counsel. I have been involved with opposing counsel who, while I believe represented the best interests of their clients, they took the typical position of an adversary as though litigation was inevitable, almost as though they were in litigation, even though this is long before litigation was filed. And that's just not helpful. I mean, it may be helpful to prolonging the dispute, but it's not helpful to the clients. And we as attorneys have a duty to represent our clients' best interests, not our own pecuniary interests. Shaping expectations. That's important because while we want to get to a resolution, we don't want to mislead our own client or the other party that something is very easy or that there's a clear resolution. Sometimes it may seem like the resolution will be clear, but hold off on sort of painting that picture and then maybe finding out additional information that would complicate that resolution. Parties often, especially by the time they talk to attorneys, have this idea that, you know, we can't resolve our dispute. We're going to have our day in court, and I'm going to have my side heard by a fair and impartial arbiter, and, you know, I'm going to be proved to be right. That is a lovely vision. It is generally impossible to get that. You know, over 90% of cases, civil cases, settle before trial. So 9 times out of 10, just by the statistics, your client is never going to see the inside of a courtroom. Of those 10%, generally there's something that went way wrong with the case and it should have never gone to trial anyway. So the idea that your client will have their day in court is unrealistic. You need to explain that to your client and try to find other ways that they can express themselves and feel like they're heard and understood. And you as the attorney have a big role to play in doing that. Listen and accommodate, of course, and then understand the external factors. Clearly, there can be differences in age between neighbors. And often I see this where new parties move to a neighborhood. They may be young, they have children, most of the neighbors are older. That can create differences of perception that can lead to conflicts. Education, wealth, personality differences, all of those things play a role. If you as the attorney can kind of step into the shoes of the neighbors and try to see things from their point of view and understand how these external factors may be contributing to the dispute, it will help you find a resolution. I am looking at the questions now, and it says, I cannot find Paul on the CalBar website. Where is he located? His phone number or website? So my last name is Mabry, M-A-B-R-Y. And if you look up my name, Paul Mabry, in the CalBar website, I'm sure you will find it. My website is landsurveylaw.com. I will say at this time, I am not taking on any new clients because I am so swamped with my current workload. But my phone number is on the website, and if anyone does want to call me, I'm happy to talk to them. We have a couple of other things coming up in the chat. So Kent asks a question, who is more likely to be accurate regarding the location of a lot line? A representative of a title insurance company at some time in the past, or a licensed surveyor who did a survey in 2023? So Kent, I'm happy to, we're gonna talk a little bit about surveying later on. So if we don't answer your question then, remind me and you can ask that more clearly, but I think it'll be the land surveyor. And there's a question about the recording of this website. So Stephen will take care of that, but I believe it'll be available through the law library's website. So going back to our discussion. So looking at how uncertain boundaries can create either a direct or a sort of abstract reason for property owners to have disputes. So I've never had a property owner yet tell me that they didn't understand that their property is different from their neighbor's property. I think that's kind of built into from our earliest days as toddlers, we kind of have a concept of what's mine and what's not mine. The problem in California is that the location of lot lines are often not monumented, and what is perceived to be the lot line may or may not be reliable. But that uncertainty, which there may be a little bit of uncertainty, there may be a lot of uncertainty, it creates something between the neighbors that erodes the trust that they would normally have with each other. And that then can lead to emotional exchanges, which, escalate into, real conflict. So I've had, I've had experience with both trees, water, ingress and egress rights. Almost anything that's located near a boundary can be an example. But one example would be a case that I was involved in involved a tree. It was a very messy tree located near a property line. And the way the fences had been, it was a little unclear to the neighbors whether the tree belonged to one or the other. Well, that tree became, the uncertainty of the property line became such an issue that it led eventually to litigation. And I wrote an article about this in the Real Property Reporter last year. So I won't go into all the details, but it resulted in serious financial harm to both parties, emotional embitteredness between the two property owners, such that they never spoke to each other again and wound up selling their properties and moving away. And even, one of the parties believed that it led to the death of his spouse. So there's some terrible consequences from these things. And in this case, it was all related to an uncertainty of 18 inches or so of a tree. Whose property was it on? So, as attorneys, our responsibility is to try to help our clients. And is there a way we can step in and resolve this? And certainly for boundary uncertainty, there is, because the simple resolution is we can hire a surveyor, and for a relatively small cost, resolve that source of uncertainty. Let's talk about a few other obstacles to resolution. So there's the adversarial nature of the common law. What I try to do in my practice is maintain as neutral of a position as I can for as long as I can in disputes between neighbors. Because the common law, because our legal system has this adversarial aspect, we have to accept that. We can't ignore that, but we also don't have to indulge it. And for the most part, I found other attorneys in disputes that I'm involved in that also held a similar point of view to mine, but not all of them. Be cautious about facts that can be easily manipulated or confused. When we're talking about legal descriptions in California, they're often written in a form that's difficult to understand. And when you combine that with the history that neighbors have that may go back years, and other things like fences being built in certain locations, you can get a fact pattern which is extremely complex, and a slight change one way or another changes sort of the outcome or the perception of the parties. So be careful, be forewarned. That is going to come up, and try to understand what those are and try to resolve them. Tax assessor maps are the most common maps that people have for property. They're used for tax purposes, and so they're easily sort of pulled out, and one party will show another party, well, this is, this is what the tax assessor says. It must have some basis, right? And tax assessor maps are not reliable. They're a basis for collecting taxes, and that's what they're used for. So don't rely on a tax assessor map. This idea of property rights, we don't have any property duties. We have this bundle of sticks we often analogize to that says, have the right to exclude someone. You have a right to, the quiet enjoyment of your property. You have lots of rights, but we also have not legal duties, but at least social duties to also bring into this account, and reminding our clients of these things and helping them to understand their duties to help resolve their problems will make this more of a win-win and less of a zero-sum game where somebody's going to win or somebody's going to lose, and somebody's going to lose worse. Because when it comes to litigation over property disputes, it's a lose-lose situation. So we're going to take a quick look on this next slide at this case, Hudson v. Kwan. This is not being cited for law, but it does show that courts have a broad range of powers, including their equitable powers. And when neighbors act badly, the judge can take those things into consideration later and punish one party. So in this case, we see that Janet hears what sounds like a chainsaw, and it turns out that her neighbor was like cutting down this fence, which they had both agreed was not in the right location, but had been there a long time, and they hadn't come to an agreement about what to do about it. In that case, the judge issued an equitable easement, which is unusual, for exclusive use of a piece of this property that was in dispute. So the plaintiff in this case won the case and received the right to use her neighbor's property up to where the old fence had been, even though that wasn't her property. And that was essentially a punishment for the owner's bad behavior. Those types of outcomes are really unpredictable and certainly don't follow the legal principles that we as attorneys can advise on. But I'm just saying it is possible that bad conduct will be punished later in ways that are really tough to figure out, tough to predict. So why is California land so susceptible to boundary uncertainty? And I'm saying this because although I'm not licensed to practice law in other states, I have practiced land surveying in quite a few other states. And, California has a uniquely different approach to land than most of the other states I've worked in. That goes back to to some of the the fundamental things about how California was developed over the years. So most land in California has been developed prior to 1972, and that was when the legislature amended the Subdivision Map Act to include quite a few requirements that for mass subdivision of lots, you need to have land that's been surveyed for one, and then charted on a map and recorded for everybody to understand what was done. Unfortunately, we don't have a requirement that lot corners be monumented. And so both local and county legislation may or may not require that property corners be set when lots are created. But for the most part, I would say subdivisions in California that were done before the 1960s will not have corners set on the lots. And so neighbors have no way of knowing where their property corners are located. As best I can understand, listening to old surveyors and people who understood how land development was done in the early part of the 1900s, the surveyors at that time would set wood corners for the developers so that the developers could put in fences. And that was the basis for the original development. Well, those wood corners have long since disappeared. They had no identifying marks on them. And so although a fence line that's been existing for a long time may be in the right location, it may mark a property line. There's no way of knowing that. So that creates a lot of problems in California. Most descriptions that we have prior to the 1970s, they're in a form called meets and bounds. We're going to look at one in just a minute. And those descriptions are hard to read. I mean, it's impossible for a layperson to understand those things. It requires an understanding of math and trigonometry, and then to put that on the ground is beyond the ability of most people. So that further, that's the basis of what you own. That describes what you own legally, and yet you can't really translate that to the real world. That's a problem. Sometimes, especially I work a lot for title companies that are trying to figure out historical title problems. Oftentimes I find that since the public lands were surveyed in the mid 1800s, there has been no subsequent survey. That's just crazy. It's almost impossible to think that there would not be conflicts between neighbors when there may have been no survey on a piece of property that's conveyed and subdivided dozens of times in 150 years. So this is a reference at the bottom of the screen here to the article I was mentioning to you guys. And if you're able to reference that and you're interested, it's a good reference. So let's take a look here at an example of a meets and bounds. Sorry, I'm not looking at our chat here. We've got a couple of other questions. Let me. So here we've got one from Linda, and we're just about halfway through our time here, so I think we're doing well. What can concerned citizens do to encourage the ABA and to make the change and encourage the state and/or California attorneys to better define boundaries in attached condominiums and townhouses with shared walls, floors, and ceilings? Condos and other homes in a common interest development governed by an association, often a homeowners association. Yeah, so there's kind of two bodies of controlling regulations. One for subdivision map act subdivisions that aren't common interest developments, and then the other is the laws around condominiums. Both of those are really lacking in some key fundamental ways that would make it easier to define those boundaries at the time they're developed. Unfortunately, the lobbies that are also interested in land development have made it very difficult to amend those statutes to better define those boundaries. Often because there's some additional cost involved in monumenting the boundaries. And this is kind of a result of just the process that we have in California for approving new development. So let me kind of give an example. In most states, and the way that things would be done most efficiently, you would have the surveyor survey the whole property that you wanted to develop, and then you would plat the new lots. You'd put that on a map and show this is where we want to put all these new lines. Then you would have a developer come in and he would build within those lots. And of course, there would be some back and forth with the surveyor to explain to the developer, this is where this house goes, this is where this house goes. And then at the end of the process, the surveyor would go in after all that construction is complete, and he would monument then for permanent record all the lot corners. That's the way it's done in many states. In California, we often approve the subdivision map months or years ahead of development. And there are conditions which will be placed, which are supposed to say how that monumentation is done. But the enforcement mechanism through the MAP Act, it terminates at the time the map is recorded. So the map will be platted, recorded long before development is done. There's no follow-up mechanism by which the developer is required to have a surveyor come back out at the end of development and put in the physical monument corners. So even if they were placed, which they're not required to be placed before development in most jurisdictions, but even if they were, by the time you get done with all your earth moving equipment and building houses, most of those corners don't exist any longer, or they've been moved from their right locations. So we really need legislation that would change the process so that the property boundaries were reestablished after development was complete. That would make the most sense and be a simple solution, but it's going to add some cost, and developers aren't interested in adding costs to their projects. The condominiums, very similar in that often in the fine print, there's a condominium map which states which walls are boundary walls and which walls are not. But again, those maps are done prior to development. Often the preliminary maps that the surveyors use to create the condominium maps and divide the three-dimensional space is based on an early design document that gets changed during construction. And so by the time construction is over, those condominium maps are no longer reliable. The walls that are supposed to be boundary walls may or may not be in the same place that they are shown on the condominium map. So it makes it very difficult, again, to understand which walls in the condominium are boundary walls, and are they located exactly according to the map, or were they changed slightly? So I hope that answers your question briefly, Linda. There's certainly a lot more technical stuff we could go through to talk about this, in different ways to clean up California development. But again, even if we did, those are all prospective, looking forward. It would change things in the future. It doesn't help us dealing with all of the properties we currently have. Do you have any good references for research on railroad setbacks? Where do you measure from, the center or the edge of tracks? That is going to be outside of what we can cover in today's talk. We're just not going to have time to explain that. Railroads are quite difficult to retrace because they use curves which are not simple radial curves, which is what's used everywhere else. So dealing with spiral curves can make it very difficult to figure out how to retrace what a railroad right-of-way looks like. But in short, that would be the domain of a surveyor. I would talk to a surveyor and ask, does he have any recommendations on research sites? And certainly there are some historical archives where old railroad right-of-way maps can be found and looked at. And your question, do we measure from the center or the edge of the tracks? Well, generally it's the center line of the right-of-way, but the railroad tracks may or may not be placed on the center line. So it's tough to say. And then we have one other question from Daniela. Do you have any experience with land disputes between a common interest development and private HOA members involving adverse possession claims? I'd have to think about that, but I don't think so. Certainly I don't get involved in a lot of HOA disputes. But there are some law firms. I know if you look on the internet, there's some law firms that kind of specialize in HOA writing and development and condominium development. So calling one of them might be your best bet. And they could refer you to somebody who does that. Okay, we've got a couple of other questions. I'm going to, so Linda's responding to Daniela's question there. I'm going to move on, and I'm going to come back to the next questions. Ken has one about a fence. I'll come back to that. So we'll keep going. I don't want to run out of time here. We have about 20 more minutes. So looking at this meets and bounds description, I've underlined the bounds in red. I've highlighted the meets or the measurements in yellow. And these descriptions are a combination of both boundary markers and measurements. So when we see at the top of the page a radius of 1,030 feet, again, we're talking about a simple circular curve. This would not be true in a railroad right-of-way. They often use spiral curves or spiral entrances or exit curves. So a railroad monument or a railroad description can be much, much more complicated than this. And this is complicated enough. But what it's saying is it's a curve to the right with a radius of 1030 feet to a point on a fence line. So now that fence line is actually the superseding call. But, you know, I'm guessing from the look of this description, this is an older description, probably from a record that was recorded in maybe the 40s or even before. So what are the chances that you are going to go around and find this fence line that's the boundary call? How would you know that the same fence you find today is in the same position as this fence was? These are the very real problems with a meets and bounds description that surveyors face and that property owners face. The next line, it says it calls to the lands of a party. Howland Green, I think is what it says. Again, you'd have to go back in the record to figure out who owned the property at this time period and where was Howland Green. That's complicated research that you've got to go through. So I'm not going to belabor the point, but this is just a typical example of a meets and bounds, and this is very difficult to figure out what it means on the ground. So I hope that covers a little bit of the problems about why California properties can be so complicated. Again, the lack of physical monumentation being set and the fact that many lands were described with these meets and bounds descriptions, and they're not shown on any map. There may not even be a survey of record ever. So those are all very complicating factors that create a reason for property owners to come to some sort of dispute. So I'm going to wrap up here with some of my suggestions, and then I'll go back and pick up on answering any other questions. So these are my suggestions to help facilitate resolutions. I've got some do's and some don'ts. So I'm going to go through the do nots first. So please don't be a jerk. It's simple, right? It's easy to understand, but when you get into an emotional situation, it's easy to be a jerk. And I have to admit, I have been a jerk, even though it's against my principles. So make that kind of something that you consciously are going to say, I'm not going to be a jerk today. And, you know, that will help. Avoid puffery. I mean, if you're a transactional attorney and you're dealing with a lot of, you know, deals, puffery is just part of the tools of the trade, right? It's just part of the thing you do. But try to avoid it when you're dealing with two neighbors. These are people that are going to have a relationship for a long time. Puffery will just undermine their relationship at some point in the future, if not in the current dispute. Never try to use gotcha tactics. Again, when you draft a legal document that's going to, you know, let's say you're going to draft an easement as a resolution to a dispute between two neighbors. Don't throw in some sort of provision that favors your client and harms the other party, and they're not going to be aware of for maybe ever. Just don't do it. It undermines that relationship of building trust between parties and helping reach a resolution. You'll have to be firm sometimes, but never be hostile. I always try to, you know, remember that I make mistakes. I try to be humble myself. If there's a possibility that someone has made a mistake, I try not to be reluctant to admit, hey, it might have been me. I might be the reason why we're not making progress here. Avoid ultimatums. Always leave open the option to re-engage, because oftentimes neighbors, you know, they just refuse to cooperate. But try to, you know, leave an open door. And of course, as an attorney, don't expect to get rich on these kinds of disputes. For one, you're going to be working against your own interest to resolve the problems. There's that. But oftentimes neighbors, they just can't afford to pay a lot of money for these things. There aren't any deep pockets. Some of my clients are wealthy, and I appreciate them, but they're not the ones who have disputes often. So I kind of deal with neighbor disputes as a matter of principle to try to do my part in helping neighbors resolve issues. But hopefully as an attorney you have other sources of revenue, because this is not going to be one that you'll get rich on. So the do's, on the do side, we've got communicate with candor, be emotionally sensitive, be honest, be kind, be predictable. Sometimes it's possible to sort of be unpredictable and use that as a tactic to negotiate. But personally, I try to be predictable, try to tell people what I'm doing, where I'm planning to go. I think that builds trust, and it will help reach a resolution. In the beginning of disputes, I've had the situation where my client is asking for legal advice, but I don't know whether the neighbor is represented by counsel or not, and it's just been the two neighbors dealing with each other directly. So this is not something that I'm hard and fast set on, but I have tried to stay in the background and just coach my client, coach my neighbor to say yes, do say this, don't say that. Before you send out an email, let me look at it, and maybe I'll tone it down or rephrase it, but try to work from the background. And occasionally that works, and the neighbors are able to work out their differences, and nobody knows that I was ever involved. That's not certainly the majority of cases, and generally it turns out that I do have to be involved directly, and often the neighbor is also represented by counsel, so then I'm dealing with another attorney. Take advantage of confidential settlement discussions. There is this provision to sort of encourage parties to resolve their disputes and be open and honest with each other under this confidentiality provision. Just remember that is not a blanket privilege. It is not the same as attorney-client communications. It does not provide the same level of protections. So be conscious of that. And again, if you're being honest and you're trying to reach a resolution, I don't think that's going to bite you, but do be careful with confidential settlement discussions. That it does not equate to a privileged discussion between attorney-client. Mediation services. These can be really a great gift. I wish there were more of these, and I wish there were more that focused on neighbor disputes. I'm familiar with a few, but certainly often the local bar associations will help sponsor some of these. And just by asking around to different attorneys, you may be referred to some other ones. I was just made aware this week of one in San Francisco. I think it's Conflict Resolution Services. But yeah, that is a wonderful opportunity if you have that. Take advantage of it. And then another thing that I've started doing is there's this book by Nolo Press called Neighbor Law. It's really a gem of a book, and it's written in easily accessible language. It's not a lot of legal jargon, and it pretty much covers all of the friction points between neighbors. So I will often buy that book in bulk, and I will give it to both parties whenever a dispute is coming up, if it seems appropriate, because that book can really help both parties get on the same page about what they're talking about, and not sort of having preconceptions about what the law is or isn't. As probably most of you know, adverse possession in California is very different than it is in most other states. So people that have concepts preconceptions about what adverse possession means in California are often incorrect. So having a book like this can be really helpful as well. That wraps up my my presentation. We have about 10 minutes left, so I'm going to look at the chat and see if we have some more questions here, and if you know, if anybody wants to raise their hand and be recognized, I will do my best to do that, although I can't see all the hands. So Ken is asking a question: if a fence is on the neighbor's property, would that homeowner be totally responsible for replacing the fence when it falls down? So Ken, that's a great question. It's a typical point of dispute between neighbors, and it really depends on who built the fence and whether it was a joint fence, a common fence between the owners. California has the Good Neighbor Fence Act of 2013, which clarifies kind of what some of the presumptions are for a shared fence and how that should be dealt with. So I would start with the 2013 Good Neighbor Fence Act and try to fit that to your facts and see if it makes sense. But the short answer is a fence doesn't have to be on the property line to be jointly maintained by the neighbors, and it may or may not be in the, belonging to a single neighbor. I've also seen kind of the opposite situation where neighbors clearly intended to build a fence on their property because the other neighbor wouldn't cooperate. But then after the years go by, nobody knows that. And so it creates a lot of confusion and potential dispute, friction points, especially when you have new neighbors that move in. Okay, so another thing here is that the condo question that I was talking about before was an apartment conversion. So those are a little different in that the condo.
Paul, I wanted to ask a question.
Yes, go ahead. Yeah, go ahead. Ask your question.
Ask a question. Do there be issues in the property line and the sidewalk between the city and the property owner? Like, who owns the sidewalk?
Yeah, so you're breaking up a little on your question, but I'll restate it and you tell me if I got it right. So your question is, you've got a sidewalk in front of your property, the property line separates your property from the street right of way, and you're asking who's responsible for the sidewalk and where does it lie, on the city's property or on your property? Did I get that correct?
Yes.
Okay, so that's a little tricky on the maintenance of the sidewalk because several of the local cities have ordinances that make the sidewalk the responsibility of the adjoining homeowner for repair, even though it's not on their property. So you'd need to look at your local city ordinances and see what it says about sidewalk maintenance. San Francisco, for example, has adjoining property owners maintain the sidewalk on their properties. In my hometown of Alameda, it's not that way. The city maintains the sidewalks. Now, determining where the sidewalk is located, sometimes sidewalks are built off of the street right of way, and they may be in the private property owner's right of way. So to know that, you could look at the Alameda County Surveyor's website. They have a great resource there where you can look up surveys, and you could see if there's a survey done on your property or in the neighborhood that would delineate where that property line is and give you some landmarks or some survey monuments that you could look for and then try to find out where the sidewalk is. If you're really lucky, you would find out that the survey is actually shown, or that the sidewalk is actually shown on a survey map, and that would tell you the answer. But yeah, the short answer is it's really difficult to know. Generally, in development, cities will try to build the sidewalk within the width of the road right of way, along with the road, the path of travel for the road itself. So, that's the intent. So often, I would say most of the time, sidewalks are built within the road right of way, but they may not be built right up to the edge of the right of way. Often there's some buffer space between the back of the sidewalk and the private fronting, abutting property owner's home. So, okay, so I was talking about the condo conversion. The question that I was talking about before, the questioner clarified that it's an apartment that was converted to condominiums. So that is common in the Bay Area. Typically, if you look on the recorded subdivision maps for the county, you will find a map that shows your condo conversion, and it should show the actual wall layout of the inside of the building on the condominium map. If it does, then that is pretty easy to follow on determining where the party lines are, where the party walls are, where the property lines are inside the building. If it doesn't, you know, I'd have to look at it to give you any more specific advice on, but generally, at least in the 80s and early, I mean, in 80s, 90s, and early 2000s, the condo conversions were pretty clear in the maps that were recorded. And then more lately, not so much for some reasons that I won't go into. Hillary asked about a certificate of attendance if you are an attorney. I know that only attorneys get the MCLE compliance. That's what that certificate states, is that you get credit for an hour of attendance, but I don't know if there's a certificate otherwise, Hillary. The certificate is a state bar certificate. It seems like some paralegals have asked for one as proof that they attended. Okay, yeah, that's more of a statement. I don't know about that for paralegals. Yeah, so then there's a question. Ken asks about the right to quiet enjoyment. What do I do with a neighbor whose dog barks constantly? So, you know, Ken, I think I would grab that book I mentioned to you, the No Law book. It's got a section on nuisances, and dogs frequently do pose a nuisance. So take a look at that, follow that advice as sort of a starting point to kind of familiarize yourself with the laws around nuisance. And of course, you know, get in touch with an attorney that can advise you more specifically about that. But yeah, certainly dogs can create a nuisance and can be difficult to resolve, because unfortunately, you know, some things can be remedied, and once you do it once, it's done. But a dog, you know, continues to live next to you, and what you think resolves it one week might not be working the next week. So that can be, those kind of continuing nuisance situations can be a problem. Can you provide any guidance or sources on trees that present a danger from falling or fire to structures on adjacent properties? You know, I don't. I would say you probably, you know, anytime there's a threat of harm to property or to a person, you probably should talk to an attorney. The Alameda County Bar Association has a referral on their website where you can talk to an attorney for, you know, the initial consultation. It doesn't cost anything. I'd recommend that for that kind of subject, because there could be something that's dangerous and you don't want to, you know, just wait on that. But, you know, if you wanted to just familiarize yourself on some of the rules that are around trees and falling objects, again, that NOLO law book is a good starting point. Megan points out that Seeds in Berkeley is a great resource. Ken has my question regarding title company's advice versus surveyor. Yeah, so Ken had asked this question, you know, do you follow the title company's advice or a surveyor? So let me just say a title company isn't qualified to make any statements about where a property line is located. So I think either the title company is negligently providing advice or is being misunderstood in what they're saying. And I don't know which would be more applicable there, but you know, none of the title companies that I work with would advise a client about where their property line was located. So I would absolutely say talk to a surveyor. Do not rely on your title company for advice about the location of a property line. Now, if the title company is advising on other somewhat related things, like what rights do you have, sometimes those issues can get intermixed between where a property line is located as opposed to what rights do you have. So, you know, what I'm saying, take with a grain of salt, because the title company is probably saying something for a reason, but I don't understand from your question why they would be advising about the location of a property line. So again, yeah, all of these questions is talk to an attorney and let them give you some specific legal advice. So we have a thing here. We have a paralegal, Derek, and needs proof of attendance. Community boards in San Francisco, absolutely wonderful organization. I've dealt with them over the years many times. Best resource for reviewing adverse possession claims for a tenancy in common. That's interesting. Tenancies in common and adverse possession. I think probably you should talk to an attorney, Eli. I don't know of just a general research for that specific question that I could refer you to.